Yeah, Olivia did. Sure. And we're live. Okay. Good afternoon, everyone. This is the Senate Government Operations Committee on Thursday, March 21st. And we're gonna start to have a little discussion about H 649 relating to the Truth and Reconciliation Commission. Here's some extra ones, Senator. No, you got it? Okay, does anyone else need it?
I just needed to remind.
All right, so we have the chair of the House Gov Ops Committee with us, and he's gonna give us a little overview of your work on the bill.
Great. Well, thanks for having me. For the record, Representative Mike McCarthy, I'm the chair of the House Government Operations and Military Affairs Committee, and I reported H 649 on the House side. So this is a bill that is first and foremost designed to help the Truth and Reconciliation Commission actually do its work. So you might recall when we passed the bill last biennium that became Act 128 and established the Truth and Reconciliation Commission, it had a very elaborate kind of three-stage appointment process that was designed to make sure that different types of stakeholders had input on who eventually were the three commissioners. And the initial committee that set up the nominating committee and dissolved, and then the nominating committee dissolved, and then you were left with the three commissioners. And we had isolated it so well from political influence that we actually didn't have a way to fill a vacancy. So the thing that this does first and foremost is that it fills a vacancy. It provides a process to relatively quickly reappoint the nominating panel. I'm imagining that in reality, it would mostly be the same people who were a few months ago on that nominating panel, and that they would help fill the vacancy for the third commissioner, which has been made vacant due to a resignation. So that's kind of the first big thing that this bill does. And then the Truth and Reconciliation Commission, the General Counsel, and the commissioners asked us for a number of other powers and sort of updates to their abilities and responsibilities. So Damian can walk you through some of the details probably better than I can, but we are going to grant them the power to establish some support groups. So we're giving them basically the ability to have what we originally called affinity groups. We took that word out so it wasn't so specific. But we're empowering them to essentially have set up these groups so that folks who share what can be really traumatic stories could come together afterward, and they could potentially have a person facilitate conversations to help people share their experiences together. Those would not be part of the record that the Truth and Reconciliation Commission is creating, but these would be something that the Truth and Reconciliation Commission thought it might be useful to facilitate, especially in these cases where a group of individuals might be served and helped through some of the trauma of having to share their stories by coming together after they testify before the commission as a resource. There were some things that we were requested to do that we decided to do here to protect the Truth and Reconciliation Commission that I would be totally frank with you, you're going to hear from folks from the Press Association and others that they have concerns about the limits on the public process here. So we created an ability for the Truth and Reconciliation Commission to essentially limit access to its meetings in a couple of different ways if there is a specific threat against the health and safety of the commissioners or participants in the meeting. So if there's a threat to their safety and they identify and that on the record, they can, for the purposes of a remote access, they can essentially do what we do here, where they can limit access to the Zoom. And they, for the purposes of their physical location, can essentially close that and limit access. We made some provisions so that people known to the commission or the media could still be present in person. All of those limited access meetings would still be recorded and still be part of the record unless there, was cause to go into executive session. So that's a new power. We also talked about the other sort of really key highlight in terms of the access to meetings that's separate from the limited access piece is that we like some other quasi judicial bodies, we allow the Truth and Reconciliation Commission to deliberate without having an official warned meeting. This is an acknowledgement of the fact that the Truth and Reconciliation Commission isn't like other bodies that just meet and then go off and do things. They are 3 people full-time that are supposed to be collecting narrative data and digging into the experiences and preparing a comprehensive report about harm that's been caused to various groups of Vermonters, potentially by state policy. And so they need to be able to do deliberative work without necessarily calling a meeting, but any decisions that they make would still have to be made on the record. Any facts that they want to get into the record would have to be made at their public meetings, but they would have the ability to plan and do deliberative work in an office together without having to warn a meeting. Yeah, those are the big highlights of the bill.
So where are they? I mean, they're full-time, they're like every day, 9, Monday through Friday, where are they housed?
Yeah, so they did set up an office, and I apologize right now that I can't remember exactly where their office is, but they've been
Actually, they didn't.
Yeah.
They were about to.
Yeah.
And then the flood hit. They had been working remotely.
Yeah.
Around the state. So I don't know if they fixed that at this point, but they did not get to. They were about to set it up. Floods hit and the state office space got, as you know, just thrown into chaos as they were trying to find space. So
I would highly recommend talking to their general counsel and the 2 appointed commissioners, Mina Schultz and Melody Mackin. They have been doing research with the state archives, with research staff. They have held public meetings already and public information sessions in locations across the state and virtually, I believe. So they've done some significant work in the last few months, but they're definitely hamstrung by not having the 3rd commissioner be appointed. So
What's the second one saying? It's Mia and
Melody Walker Mackin. It's the other commissioner. And full disclosure, she and I are both alums of Missisquoi Valley Union High School. I went to school with
that's right, I remember you saying.
Commissioner Mackin.
We've already invited them in the next meeting, so, or Olivia's doing that. Senator Bukowski?
My question, and Mike, we just sent you, the meeting bill that's 55, so you may not know the answer, but it may be a bit of a question for the rest of the committee, but my question, so we created under that sort of mandatory hybrid for state boards and commissions, unless they're just advisory. And if they are not just advisory, there's this exception for a local incident. And my understanding of the committee discussion is that safety concerns fell under that. So would that exception already sort of exist in the new open meeting language?
So we worked really hard to try to make sure that we didn't sort of step on the work that we were anticipating you all doing in S55. Senator Bukowski, I don't know specifically on that score. The thing that we were focused on was that initially they wanted us to extend their ability to do hybrid meetings, basically everything we did in Act 1 in this bill. And we said, no, we're not going to do that because we're taking that up in S55. So we yanked that out of the bill as introduced. But on that, I don't know if there's any.
Yeah, I think that's a good thing for us to sort of dive into when we look at the bill in more detail. Cause I thought of that too, we could make it match better. I'm not sure it does quite, but the other thing is that the Truth and Reconciliation, what the powers of that, their duties and powers are what exactly?
I would say what it boils down to is that they're going to gather information and write a report and make recommendations. I think they have more power and resources to do that in really specific ways in regard to how state policy has impacted Vermonters than any other board or commission that we've ever set up. But they don't have the ability to adopt policy on their own. They're not quasi-judicial. I think there have been conversations around the Truth and Reconciliation Commission that have implied by people, especially who are opposed to this process, that they'd be able to like impose something like reparations or anything like that. And they just don't have the power to do any of that kind of policy setting.
They are just purely advisory.
Yeah, they fall within the definition of advisory
That's
body
right.
that you created in S
Okay,
55.
that's what I thought as well.
Yeah,
All right, well, we can try to.
Yeah.
See if we can make the language consistent, if it isn't already, it may be, I don't know.
I think if it accomplishes if it solves the concern that they had about threats to their safety, because I think this particular body has more targets on them from some corners of the internet and society, than your average public body. And they wanted to particularly make sure they had the ability to continue to work with especially vulnerable people, even after some of those threats. So as long as we can honor that concern, I think that the House would be happy to have a consistent policy across bodies as opposed to just giving them this one exception. They are a little different than any other commission we've ever set up though. So it's,
Yeah,
They
and
are very
next,
it could go both ways.
I'm assuming next week or the week after you'll take up S50 or start to, and when I come over there, I can sort of talk through the provisions of that.
It'd be good to have everything sync up.
Yeah, I think it would be too, so,
And please rename it.
yeah, I have a little list that we have to rename that.
Yeah, we need to we should have renamed it the open meeting law.
Yeah, anyway.
I
We'll
want
get
to
to
be
that.
clear that I don't want in any way to not allow them to protect their safety. My understanding from the way we worded S55 is it may already do it.
Great. Yeah, and if so,
Potentially, yeah,
consistency is good.
yeah. Okay,
We like
cool.
consistency.
Sometimes.
Well,
The hobgoblin little things.
thank you, Mike, unless there's more, Allison continues to take pictures.
No, I didn't try to get a great picture of Mike, I just have been working it's like, we don't get that many house members. I've got so many great pictures of Damien, I don't need to.
If you don't need anything from me, I'm gonna head back up to the floor.
Thank you, Ralph McCarthy.
Joy.
And I'll be
Have
here
fun on the
attempting.
floor.
Good luck.
We're gonna have Damien up here and Allison's gonna put away her phone so that.
okay.
He's not afraid of any.
The good thing about Senator Clarkson's phone is that it's bright red, so you always know when you're getting photographed.
And not always. I have gotten one of my greatest ones is of you and your daughter when she was small, when she was with us.
All right, so can you take us through the bill?
I can. For the record, I'm Damon Leonard from the Office of Legislative Counsel. So, I think Representative McCarthy did a good job giving you sort of background on the bill. What you're gonna see at the start, and I think he didn't touch on this, is you'll see that, and you're gonna see this repeated throughout. So in section 1, we have delayed the sunset for the authorization for the Truth and Reconciliation Commission by 10 months. Because of some of the delays they've experienced. The appointments occurred slower than planned. The floods this summer derailed some of their initial work. They lost a commissioner in the fall, so they asked for an extension to do their work, and so that's what you'll see. In section 2, it's the same thing. In section 3, this is the reestablishment of a selection panel. Those of you who were with us 2 years ago will remember that the original selection panel process was a very complicated multi-step process. We've simplified it. It is just 5 members. They are, 2 of them have to be, or 3 of them have to be appointed. But after that, they serve until the commission is done. So there will be hopefully no more reappointments, and if there is a need for a reappointment, the appointing authority can just fill the vacancy.
Okay, that's great, that's good. But it's not 3 steps anymore, it's 1 steps.
It's just 2 steps. It really is, this panel gets put together as soon as they're ready. They have 60 days to fill the existing vacancy. And then if another vacancy occurs on the commission, they have 60 days to fill it.
Got it, okay. Senator Roski?
So my understanding of the way we use, is this Truth and Reconciliation Commission meant to truly just be done on May 1st of 2027? Because my understanding of the way we historically have used sunsets is a time to review whether or not that commission should continue to exist or not.
So the thinking is that if they stay as an advisory panel that just did reporting, their purpose may be finished at that point, or there was discussion when they were enacted that there may be additional reports the General Assembly wants to seek. The difficulty is whether the commissioners want to keep serving.
Right.
It's a particularly intensive job. And so there may be additional discussion in 2025, 2026 about either further extending things because they need more time for their work or so forth. But one of the things that when we did the initial legislation was to put a hard deadline on it, just so that it would require us to come back instead of creating a permanent commission. Because it may be that instead of continuing the Truth and Reconciliation Commission, you want to create a different board or commission to address some of their recommendations and help implement it, and that could be different people. So right now it's a hard deadline, but like any other sunset, it may call for reconsideration.
Yeah, my understanding is we had just gotten into the habit of putting sunsets on all of our boards and commissions so that we had a date certain to review the work they're doing and whether or not we need to change anything. And so I just want to make sure people are aware that this doesn't necessarily mean they're done May
No.
1st.
No, and part of this also gets back to, there was a big emphasis among some members of this body when this passed that the authorization and crafting of solutions should come from the General Assembly. So again, that whole idea of coming back to it and thinking about whether to continue the commission or to move in different directions at that point.
Senator Larson has a.
Yeah, and just remind me, Damien, what the resources they have available to them. Do they have any staff?
They do. So they have an executive director, a researcher, one legal counsel, and an administrative assistant. So they have 4 staff. They should have 3 full-time commissioners. They only have 2 at this point. And as we'll talk about in a moment, because we forgot to give them an exemption from the quorum requirement under the open meeting law, their 2 commissioners cannot meet with each other without noticing an open meeting. So, and that was an oversight when we were drafting and preparing this bill. And so they have been hamstrung a bit at this point. They are working, but right now they're doing a lot of the communications between the commissioners that are not occurring at meeting are basically occurring through council or the executive director, or they're meeting with them on discrete projects. And they can tell you a little bit more about their work process at this point, but we do give them an exemption for deliberative discussions similar to what we do for quasi judicial bodies, so that they can actually have a meeting with each other to talk about, well, this is the direction we want to go based on this research that we did and what we found, so that they can do that sort of planning. A couple other things to note, getting back to the selection panel, is that in the original bill, they had authorizations for staff and office space. They don't have that anymore. They are allowed, though, to use the TRC staff or the Truth and Reconciliation Commission. I'm just going to say TRC because it's quicker at this point, to help them carry out their duties as necessary. Okay. Lost my place for a second. The other thing is the members of the selection panel can be removed if for some reason there's something like failure to do their job or something like that, and then the appointing authority can put in someone new. This brings us to the selection of the commissioners. The big change here, I mentioned it already, they have to fill any vacancies within 60 days. And in section 5, which if you're following along is on page 5,
Yeah.
the existing vacancy has to be filled within 60 days after the members of the selection panel are appointed whenever that is.
This is still months away as we.
Yes,
Jeez.
yeah,
Okay, I can't believe we can't do something in the interim to enable them to get to work a little more effectively.
we,
You thought about that?
well, when we had the legislative process on this, we originally had a process for removing and appointing new commissioners. In the original bill, we took it out because we were concerned about politicizing the commission if they started to dig into places where members of this body or other officials in state government were uncomfortable. And unfortunately, the way we did that, when we discussed this on the record, the feeling was that the commissioners were going to be committed for the long term, and no one foresaw an instance arising where a commissioner started the work and realized that they wanted to focus more on their academic work and resign from the commission after a few months. So that's where we are. I think it could be characterized as a miscalculation by this body.
So
You
there's
know,
no
but
executive order, there's no executive action that could be
there's
taken.
no, they are insulated from the governor as well, just like the legislature. So we left them as an island with no bridge.
And no
We took the
path,
bridge out basically after we put
bridge
them on
out,
the
no
island.
canoes, no path.
And
I
so
mean,
we're,
with good intentions, so.
With good
it was
intentions,
not
but-
that, like,
Lots of things.
it was a well-intentioned bridge removal.
I guess actually you could think of it as a moat, and we forgot to leave a drawbridge.
Yeah,
And so this part of the bill can be seen as building the drawbridge. So that they're still insulated, but there's the ability to send a new commissioner over if they need it.
And to protect them, just like a good cat.
Yes, but that also brings us to section 6, and the commissioners themselves asked for this. And this is a provision allowing the selection panel to actually remove one of the commissioners for incompetence, failure to discharge their duties, malfeasance, illegal acts, or other actions that would substantially or materially harm the credibility of the commission or its ability to carry out its work. And they asked for this because they said, their testimony, if I can paraphrase, is our ability to do our job depends on our credibility. And if one of us does something that harms that credibility, you should have the ability to remove us and replace us.
Which is sort of what happened, which is why we were down the commission.
So, so we're down a commissioner. They want the ability to, if something goes wrong in the future, to have a replacement so that at least the credibility of the commission survives. So that's what section 6 is all about. It would require a majority vote of the selection panel to do it. Section 7 is the powers and duties. Representative McCarthy touched on this. Part of their charge is to look at ways to start facilitating healing by parties that have been harmed by the state. This allows them to establish essentially support groups in which individuals who have experienced discrimination or are part of a community that experienced discrimination can participate. It forbids the commissioners from participating because we don't want to trigger the open meeting law. We want these groups are confidential. And while the groups can continue to exist after the commission ceases to exist, commission staff and commission funds can no longer be used to support those groups after that date.
after,
The date the commission ceases to exist, so
Oh,
that's
okay.
May 1, 2027.
okay, so these groups, I was about to ask, can't these groups be established anyway? Why does the commission need?
The commission wants to have the ability to facilitate the groups forming. So for example, what they do is confidential, but they want to be able to say, there's a support group, similar, there's a meeting of people who have experienced similar trauma or who have a family member who was sterilized by the state. or something like that. It meets the first Tuesday of every month in Middlebury. If you're interested, you could attend, and it's a confidential meeting. It's
And
totally
they're-
up to you, and so they just would be there to facilitate these individuals being able to meet with each other. Commission staff may help facilitate the meetings, but the intent is that they would be handing it over to someone who's a professional trained in sort of group therapy settings. And this is not my area of expertise, so if my terminology is not correct, please bear with me. But
Sorry, Ben.
so far, okay, good. But they would, the idea is basically that they would facilitate connecting these people to these groups, because the individuals may not know that the other individuals exist or may not have that direct connection.
Okay, and the commission, by having their staff facilitate and everything, so the budget of the commission is also supporting these groups. And
The
that
budget
that's why
is
it's important
involved
that they-
because they may be,
Yeah.
the staff may be involved in helping to facilitate organizing the meetings or things like that, arranging meeting space. Providing a stipend for a professional who helps facilitate the discussions. That sort of thing, and they want to make sure that the two things they wanted to make sure of is, one, while the commissioners can interview these individuals separately, they don't want the commissioners participating in the group session because they don't want it to trigger any public record or open meeting requirement. Or to create some ambiguity about that.
Yeah.
And then the other piece, the other concern that was raised by some members in the House was, we don't want this to become a line item in the budget. Long term, it's fine if the commission establishes these meetings and uses their resources to help facilitate this, but once they cease to exist, if the groups want to continue meeting, they'll have to fund it on their own.
Got it, okay,
So
Is there, sorry,
go ahead, yep.
so is there any, a budget for sort of expert witnesses or
the commission hasn't,
snacks or something?
the
Wait, do they
commission
have
has
any-
an operating budget every year.
Of course, Allison.
Food, I mean,
Sorry
I'm
about
like, totally food stuff.
Right, the commission has an operating budget. They can tell you more about that. My understanding is it's a very lean budget at this point.
Yeah. It's-
And so I don't know how much monetary resources the commission will put into this, except for the salary of the individuals helping to facilitate organizing the meetings. But it's out there. My guess is they'll be looking for meeting space in the community that is free or extremely low cost, and trying to find, they do have the power to seek out grants and so forth, so they may be seeking some of that funding to help facilitate this if they move in that direction. Their ask was, we would like to have the clear authority to do this, because we think it's something that may be a way to start helping healing. Long before we're able to issue a report and ask for legislative action.
We have a long tradition of group healing process. You know. I'm just, yes.
Restorative justice world.
All
with this too.
So the next section, which really is on section 7, deals with the reports required from the commission. Subsection A relates to a report that they already submitted, which you can find on your legislative website. Subsection B would basically just move out the report dates for the final report out by 10 months to April of 2027, and the draft of it out by 10 months to October of 2026. So basically, they issue a draft report about 6 months before they issue a final report in order to allow for public comment on the report and a process there. But this is just related to moving those dates. And at the very end on line 19, there was a typo in the original law. We fixed a technical correction.
Oh, good for
That brings us to the
To the access.
the public access and information, so. The change at the beginning of page 8, lines 5 through 7 is adding in a cross-reference that was left out in the initial law. To laws that are in conflict with this language, so we're saying notwithstanding those laws. The commission shall permit individuals who are interviewed to have a private interview rather than have an interview during an open meeting. Again, the goal here is to protect the confidentiality of individuals who have experienced harm so that they're willing to come forward and speak with the commission without worrying that, my great aunt's medical history and the fact that she was sterilized and had an intellectual disability is not going to be aired for the world, and I won't have to share this incredibly painful memory with the world. Section 10 gets into the limited access meetings that Representative McCarthy talked about. It defines a limited access meeting as a meeting that is live streamed and video recorded, to which access and participation by members of the general public is limited as provided in the section. So, the subdivision 2 allows the commission, upon finding that there are material threats to the health or safety of the commission, its staff, its witnesses, or its invitees, to hold a limited access meeting. And add that the commission may restrict attendance at the meeting, whether it's in person or by electronic or other means. And restrict attendance and participation to the committee or the commission staff and its counsel, persons who are providing testimony or information, members of the media, and other persons whose presence the commission determines is needed at the meeting. So the addition of members of the media was a result of discussions with the Press Association. And they're concerned that if the media couldn't be present in real time, it would be difficult for them to adequately do their job of reporting and asking questions. The commission would be required to include in any agenda for a limited access meeting information to allow the public to directly access the live stream, and the video recording of the meeting would have to be made available. Would have to be posted on their website and made available for inspection and copying under the Public Records Act. And the live stream and video recording requirement does not apply to executive sessions. I wish Tucker was still here because
I know.
he did the walkthrough on all of this.
I wish, a lot of times, probably a tougher bill that Damian was filling in for.
Yes, this,
But did you originally draft the bill?
so I'm the primary drafter on the bill, but Tucker was instrumental in getting the language right for
Yeah.
all of the open meeting pieces, and he
Yeah, no,
drafted a lot of it.
Was the
So,
drafter, but I imagine perhaps because of anticipation that Tucker wouldn't be here.
What, did you draft the original Truth and Rec bill?
oh, yeah,
Yeah.
Oh, did you?
yeah, that's on me.
Yeah.
Yeah. Yes, so the original Truth and Rec bill was me. I've worked with Tucker on all of the open meeting and public records pieces of the law at this point. And then this gets a little bit to S55 on the top of page 10, subdivision 4. It says limited access meetings shall only be conducted electronically to the extent that electronic meetings are permitted for public bodies and in a manner that is consistent with applicable laws governing electronic meetings of public bodies. So the goal of that language was in anticipation of S55 to say whatever happens in S55, we want them to basically be on the same terms. So until, was it June 30th of this year, they can continue to have fully electronic meetings. And then depending on where you end up with S55, they're going to be subject to that after that. So they're assuming that they continue to be an advisory body under that law and subject to the requirements of an advisory body. That's how it will apply going forward.
Yeah, that is.
know that they're an island technically,
Okay.
but are they not all considered a state board? because it would apply to state board.
But they're an advisory state.
So they can still be all remote.
Yeah, they don't
Which-
have any decision-making authority outside of what goes in the report.
So,
They are a public body of the state. But they're an advisory public body of the state, so they can be fully remote, and fully in person or hybrid. They, according to our version of S 55,
okay,
they don't have quasi judicial
Right.
legislative budget or tax
I
authority.
think I was just trying to remember which one was like superseded the other, like
Do you need the chart?
No, I
The language didn't say all state bodies,
With all boards and commissions unless they are advisory.
unless they're advisory, so that applied for.
But with Damien's explanation of the language, I think they are actually asking for a little bit more protection than just being remote, because they're asking for the public to not be able to participate.
Yes.
Yeah, it's a little bit more than.
This is-
Yeah,
The electronic, so yeah, it's important to note, this says limited access meetings shall only be conducted electronically to the extent that electronic meetings are allowed. The thinking was that if you didn't permit fully electronic meetings for advisory bodies, then they would basically have to be in person, but with the doors locked.
Mhm.
So, and this gets back to the concerns over threats, that they've already experienced death threats, so.
And that, I guess my question is, have they already experienced?
Yeah, they can testify to that, but they testified in the House that they have already received death threats and other threats to, commission members and staff, so it's, unfortunately, it's the nature of the world.
I wish I was surprised.
But, so that's why they've asked for this, and, there was a lot of discussion about these limited access meetings. And so part of their concern too is that, one of the options that was mentioned was, well, couldn't you have a law enforcement officer present? But the concern was that if you have people testifying who have experienced trauma at the hands of the state, having a law enforcement officer present may in some cases aggravate that trauma, or cause the person not to want to make an appearance and testify. Or if the concern is that the person who's issued the threats could still be in the audience, even though there's a law enforcement officer present, again, you may have people who just don't want to make an appearance. So that was where they ended up. Obviously, you can take testimony from the body and decide if this is the right approach, especially in light of all the work you did on S55, where I think you're particularly keyed up on this topic and ready to go.
yeah.
It's good that this is
Fresh in our
following that
minds.
work.
Yeah. So, another thing that was requested and added is subdivision 5 here, which is basically that the commission has to provide some sort of opportunity for public comment related to the agenda topics or any limited access meeting. And then any public comment received would have to be included in the record of the limited access meeting. It's not clear whether that has to be real time or just after the fact, you can submit public comment. And then they have to include it with the meeting. But again, there was concern that if you have a limited access meeting, you can stifle certain voices, and they didn't want to allow for any opportunity for voices that may be disfavored to be closed out of a limited access meeting and then not have an opportunity to be heard. And then B gets to the quorum issue with the 3-member commission. And so it basically provides that deliberations of a quorum or more of the members of the commission shall not be subject to the Vermont Open Meetings Law. The commission shall periodically post on its website a short summary of deliberative meetings. Does not require specific, like monthly or something like that, just periodically that it posts them. And then it uses the same definition of deliberations as in the open meeting law for quasi judicial bodies. So not making a decision but discussion, discussing the evidence and facts that have been presented.
Do we carve out this type of quorum exception for other public bodies?
My understanding is that this issue has come up with other public bodies. We have carved out the deliberative exception for groups such as I want to say the Public Service Board and other quasi judicial bodies. We have not carved it out, to the best of my knowledge, for an advisory body like this. So that we've carved it out when there are going to be deliberations that have to occur. Where having those deliberations in public would harm the ability of the members of the quasi judicial body to speak frankly with each other about the evidence that they've received. Or about how they're going to come down. So for example, if you have 3 members discussing and they're on the fence about whether to vote yay or nay on an application in front of them or the question in front of them, they may want to have a confidential discussion of the evidence saying, well, I found this to be persuasive and why or why not. This is definitely different. But this is based on that carve out that we created for those types of bodies.
Yeah, I mean, there's the quasi judicial deliberations carve out, and then there's the Public Utility Commission that's just exempt from all the.
Okay, so,
That's,
and then again, this is
There
where
it is.
having the Tucker and Damian show
Yeah.
was so nice, because I could just say,
yeah, but it's also helpful that we are pretty well schooled on it. I mean, we learned that, we took testimony from the Public Utility Commission about, hey, why are you exempt? And they happened since what, 1987?
Since they were founded, I think.
I don't think that they were founded, but
Oh,
since the late 80s, whenever they changed from the public service, no, that was first the Public Service Commission, and then it was the Public Utilities Commission. Anyway,
No, I certainly appreciate the challenges of quorum issues with a 3-member board or commission. I just wonder if an exception is the solution versus reconsidering 3-member boards and commissions.
it's orders.
we'll be out of quorum.
Yes.
So you could wait. I think that.
I'm almost done.
No, I'm.
So, and I'm also being called upstairs, so this is
Okay,
perfect timing.
legislative intent.
Right, so the legislative intent here, yeah,
Our chair does
this,
not.
I know, this is, we live to compliment each other.
it gets back to the discussion of. So I think one thing to understand, and you'll hear this in your testimony, is there is a great deal of concern. From advocates for government transparency, that creating things like the limited access meeting. And the confidentiality provisions is going to harm the transparency of the work this group does. And so the TRC, it's the intent of the General Assembly that the TRC work in an open, transparent, and inclusive manner to ensure credibility and integrity. Specific exceptions to the open meeting law are granted in recognition of the highly sensitive nature of their charge. And they want to enable the commission to carry out its duties in a manner that preserves the safety of participants, does not perpetuate or exacerbate harm experienced by those participants, and protects them from additional trauma. And that the limited access meeting should be utilized only when necessary to ensure safety and conducted in a manner that's trauma informed and best ensures the safety of all participants. So the last piece, and this is another thing that's worth discussion, and you may need to send this for a drive-by in judiciary. I leave that to the Senate. It's up to you.
Did the House do a drive-by in judiciary?
They did. So group sessions, this is creating an affirmative statutory duty of confidentiality for participants in those group support sessions I discussed. Including any commission staff or individuals that the commission contracts with. And then it provides teeth So if someone is harmed by a breach of that duty, they can bring a private action for damages resulting from that breach. So, and this does not limit or otherwise affect other common law duties of confidentiality, such as invasion of privacy or something like that, or false light invasion of privacy, where you've aired untrue statements about a person based on things that you've heard and then harmed their reputation or caused other harm to them. Important things to note for this, the reason why we're creating the private right of action is because there's some recent case law indicating that if you do not create a private right of action for one of these duties, then one may not exist. And then the individual has to argue that something at common law protects them. And so the goal here was to ensure that there is something they can hang their hat on without having to look to common law. And so that's what this is based on. The other thing is this is not a, you do have to be able to prove damages in order to sue under this. So this is not simply someone breached confidentiality and no harm resulted. This is someone breached confidentiality and it resulted in harm, reputation, other trauma that an individual may experience, something like that, where the breach is such that it's led to harm to the individual. So that's a really important thing to keep in mind. There is also an exception for, basically it's like a mandated reporter exception. This is, the teeth are not triggered if the disclosure relates to a threat or a statement of a plan that's made during a group session that an individual reasonably believes will result in death or bodily injury to themselves or someone else. And then the disclosure is made to law enforcement or another person who can reasonably prevent that threat. Or that the disclosure is based on reasonable suspicion of abuse or neglect of a child or vulnerable adult. So this is tracking our existing mandated reporter laws. The disclosure for abuse or neglect has to be in accordance with existing statute on that. And then the commission has to provide with advance notice of the provisions, including rights and responsibilities they may have so that they can participate knowing that this exists and they're not surprised if they say something or leave the session and reveal a confidence and then it causes problems for them at that point.
That will be hard. That will be a high bar to have to prove.
I'm sorry, what will be a high bar?
Emotional damages are kind of hard to prove.
It could be monetary damages too. If, for example, something was disclosed that led to you losing your job, or led to some other financial harm, that we are. So I can't speculate about this, but I think it's worth thinking about. We've passed laws in recent years to protect people from being fired or disciplined by their employer for being the victim of an abuse or other criminal proceeding. I can't say that this is happening, but typically we pass laws in this building because something has happened.
Well,
So
Does this, and maybe I'm just misreading it, does this make the commissioners of the Truth and Reconciliation Commission mandated reporters, or does
the
it?
commissioners aren't allowed to participate in these group sessions.
Okay, so this is a protection for the professional that might be providing to exempt them from confidentiality to meet the requirements of mandated.
Yeah, this is a protection for basically a professional or for someone else who's participating in a group meeting and reasonably believes that they've been the recipient of a threat from someone else in the meeting and they seek law enforcement assistance, or that someone has stated a plan to harm other individuals and they notify law enforcement or someone else who could prevent that harm. And then there's the protections around mandated reporting there.
Okay.
So basically, the concern was, and this was done most recently in, I believe in a community, trying to remember, I'm not good with the justice related bills, but, there was a bill that was worked on last session that allowed for folks to have meetings related to sort of restorative justice, and this language was put in that too, so that it couldn't be, so that the confidentiality provision didn't become a shield for someone to discuss sort of plans to engage in violent activity. So that was basically requested in this case again, because we're dealing with trauma from the state, and there may be discussion of engaging in violent acts towards people who are involved in that trauma. So that's where that comes from. This came out of some of the discussions in the Judiciary Committee in the House. So this was language that was requested by that committee that then this House DevOps Committee added at their request. So,
Okay.
and that really brings us to the end. The deleted section was an appropriation, which we'll have to see what happens with the big bill. So that was a request to get,
How much did they ask?
they actually asked for less than what joint fiscal projected as their needed annual appropriation, and what we had basically accepted as their, what the ongoing operating costs. They asked for, I think, a couple $100,000 less than what was in the fiscal note 2 years ago. To fund, at least fully fund their staff, because right now, what they received in the last 2 years is not adequate to pay their salaries.
So here is a good example of vacancy savings.
Oh, you should have heard the example we got this morning in judiciary.
Oh, yes.
All right, we're gonna move on because we have a secretary waiting for, no,
And-
we do not have a
I mean, I just wanna
secretary
get
for us.
some-
Okay. So we are going to, yes, we are gonna go off live then